Donald Trump, the Unitary Executive. SCOTUS considers giving presidents more power. Welcome to Law and Society. Please subscribe. Let's talk briefly about the case that was argued in front of the Supreme Court, which was Trump v. Slaughter, where Donald Trump attempted to fire the head of the Federal Trade Commission, and it was brought to the courts, and primarily brought to the courts because it is a regulatory agency that was created by Congress, and the removal process of regulatory agencies that are independent agencies is that they have to follow a process of notifying Congress and showing cause before they can remove, before the executive, the president, can remove regulatory agency heads, which are quasi-independent agencies. And these quasi-independent agencies fall anywhere between quasi-executive to quasi-legislative to quasi-judicial. But because the enforcement of these is administered by the President of the United States, especially the Federal Trade Commission, the case comes up of whether the president can unilaterally fire independent agency heads without considering what Congress has written out regarding the firing and hiring of independent agency heads. They need to be vetted by Congress, and even the firings need to be vetted by Congress. In this case, the Supreme Court seems poised to say that no, the president himself, because he is the head of the executive branch, can fire regulatory agency heads because they are employees under the executive department. Now, that is giving the president a lot of power. Essentially, it's taking away power from Congress because it is part of a legislation of how you would hire and fire regulatory agency heads, and essentially giving that power, taking that power from Congress and giving it to the executive, which for this Supreme Court doesn't seem like to me to be that big of a deal, because just last year in a case called Loper Bright, the Supreme Court took away what was known as the Chevron deference, which is that these regulatory agencies, these independent agencies, had the power to interpret the legislation and then the power to interpret the information through which these regulatory agencies were going to regulate certain aspects of our lives, whether it be the Trade Commission or the Communication Commission or the Labor Relations Board, whatever the case is. What Loper Bright did was say that no, regulatory agencies don't have that deference to be able to decide what the regulation means and how the regulations are interpreted, and that power rests in the judiciary. So in that case, the Supreme Court took away Congress's power and brought it, by way of the Chevron deference, regulatory agencies had power given to it by Congress. Now, Supreme Court takes that power away and says, no, the judiciary has the core interpretive power of these regulatory agencies. So SCOTUS took away from Congress the power of independent agency, regulatory agency interpretation of regulations. And in this case, Trump v. Slaughter, it seems that they are poised to take away from Congress's power to write legislation in order to check executive power and in order to create a balance among the three branches of government that says that Congress has the power to say the law, write the law. President's power is to enforce the law. And it is the Supreme Court's power to say what the law is. Now, in these cases, the Supreme Court is not telling us what the law is, because the law is that these regulatory agencies are to be administered in the way Congress has set up. Here, Supreme Court is telling us how they think the law should be, where the executive will solely have power over these regulatory agencies, and the Supreme Court, not Congress, will have the power in interpreting what these regulatory agencies are permitted to do, or how they interpret their regulations, how they interpret their scientific studies, how they put out regulatory guidelines. That deference given to regulatory agencies can now be challenged under Loper-Bright to say that the judiciary has the ultimate interpretive authority. So it is the Supreme Court that is tilting the balance of power away from Congress, heavily towards the executive, and leaving some interpretive power for itself. It is weakening of the separation of powers principle if the Supreme Court comes out and says that the executive has the carte blanche power to fire regulatory agency heads, regardless of what Congress says the procedure for their firing needs to be. So that's where we are, where, we are seeing that the Supreme Court has, by equitable grant of a stay, allowed roving patrols based on racial profiling to continue. They have allowed, by, again, equitable stay, the redistricting in Texas that is gerrymandered to continue. They have taken up the appeal for birthright citizenship instead of relying on the lower court's rulings that Donald Trump's executive order of birthright citizenship is not constitutional because it goes up and pits up against the 14th Amendment's birthright citizenship clause. But yet they have granted certiorari, granted them appeal, and will hear the argument. And now there's the firing of regulatory agency heads without congressional approval. And if the ruling comes out, it's going to be a heavy tilt towards vesting power in the executive, which is beginning the saga of the unitary executive. It's a theory that came up in the 80s that the executive branch has the power, all the power to enforce the laws, and they may not be stopped by Congress or the Supreme Court, despite the fact that Congress is the one that writes the laws and SCOTUS is the body that interprets the laws. SCOTUS is trying to say, no, POTUS gets to do whatever POTUS wants when it comes to any agency that is under the executive, despite the fact that they are run by regulations that have been drafted by Congress. With that said, keep your eyes on this because it is a larger picture. It is not going to impact us on a day-to-day scale until we realize that the president can essentially replace all the heads of regulatory agencies, from the EPA to the FDA to the FTC to the FCC to the Trade Relations, Labor Relations Board, all of these with loyalists, and then have the judiciary, instead of experts in those particular fields, whether it be environment or food safety, be the interpreters of what creates a safe living environment for Americans. And when that slowly starts to break down, the safety standards around us that keep us safe from poisonous gases and unclean water and unfair trade practices, skyrocketing tariffs, And we're going to hear about Donald Trump's tariffs power in the tariffs case that I hope the Supreme Court will rule soon on. And we'll get to see how far the Supreme Court bends to let the president have more power than the president ever has had. Thank you for listening. Please remember to like, share, and subscribe, and I'll talk to you soon.